Section 22 is meant, I believe, to deal with situations not contemplated by the Act. The Act discusses a recount and how a recount should be conducted. So there's no vacuum there.
That was Attorney-at-Law Mayo Robertson, who spoke with this newscast on Wednesday ahead of the much-anticipated hearing of Election Petition 88, which was filed at the High Court in 2020. The petitioners are contending that Order 60 of 2020 is and should be seen as a nullity, as it was enforced by Section 22 of the Election Laws of Ghana, which in itself is unconstitutional, citing the Separation of Powers Doctrine. The petitioners further argue that based on the Separation of Powers Doctrine, GECOM should not have the authority to amend laws and the likes. According to Article 162(1)(b) of the Constitution of Ghana, GECOM has the authority to take action as may be deemed necessary to ensure impartiality, fairness, and compliance with the provisions of Ghana's Constitution.
And we believe that is in fact delegating to GECOM impermissibly a right that is reserved to Parliament under the Constitution. Parliament makes laws. Parliament amends laws. GECOM is not supposed to be entitled to amend laws.
This newscast questioned the attorney as to whether the petitioners could not foresee that Order 60 was drafted in bad faith, as is being claimed, and therefore avoid it altogether. He retorted by saying that they had raised the matter at the level of the Court of Appeal, but this is what they were told.
So the courts never ruled on the constitutionality of Section 22. They simply said, if you want to examine Section 22, this is not the time or place. You need to go to the Election Petition Court. So here we are in the Election Petition Court.
Robertson further highlighted that the Representation of the People Act, which guides the conduct of elections in Ghana, speaks to all the difficulties arising out of elections, as well as the procedure regarding how those difficulties should be dealt with. Referencing the 2020 elections, he stated that after Region 4 Returning Officer Claremont Mingo submitted his tabulation to the Chief Election Officer Keith Lowenfield, who went ahead and declared the election results, the winner by virtue of that declaration was expected to be sworn in at that time, and any recount or proposition thereof was expected to take place via an election petition, as is outlined in the Representation of the People Act. Robertson also had this to say about Section 22 of the election laws of the country.
I think many of us, I certainly did have questions about the constitutionality of Section 22, but the circumstances never arose for it to be challenged prior to the elections.
Meanwhile, the attorney revealed to this newscast that Election Petition 99, which alleges fraudulent activities during the conduct of the 2020 elections, amounting but not limited to missing statutory documents and voter impersonation, among others, is moving swiftly at the Court of Appeal, where the Chief Justice's ruling to have that petition dismissed is being challenged. Wendell Badrie, HGP Nightly News.